Hello, DAF families. Sharon Ackah here to bring you another series of videos to enhance your special education advocacy toolkit. Our topic in this series involves discipline for students with disabilities. Having a disability or receiving special education services and accommodations does not prevent a child from being disciplined in an educational setting. However, there are certain things to know about ensuring that your student is not being subject to discriminatory practices when being disciplined. If a student has a disability, they shouldn't be punished for their behavior if it is behavior that is a manifestation of that disability. As with many things in the law, we have two authorities to rely upon when dealing with disciplinary matters: case law and statute. First, let us consider the case of Mills versus the Board of Education. This is one of the first cases that established a due process procedure for students facing suspensions or expulsions from school. In this case, we saw that the District of Columbia Public Schools were routinely suspending or expelling children with disabilities without consideration as to their disability as a contributing factor in their behavior. The courts rejected this practice, saying that there would be a hearing before such suspensions could occur. Later, we would see this concept codified in both the Individuals with Disabilities Education Act, also known as IDEA, and Section 504 of the Rehabilitation Act of 1973, often referred to as Section 504. So let us review the provisions of IDEA with respect to manifestation determination reviews. And because I think you should know the key acronyms in special education when working with the schools, let's begin to use the acronym MDR, Manifestation Determination Reviews. An MDR looks at whether there is a relationship between a child's disability and their misconduct. Again, we do this because we don't want to punish children with disabilities for their actual disability. So if the behavior that is being demonstrated is in fact directly caused by this disability, the school should be looking for ways to redirect or modify those behaviors as opposed to removing the child from the educational placement. Suspension or expulsion should not be a default response. IDEA says the following: within 10 school days of any decision to change the placement of a child with a disability because of a violation of a code of conduct, the LEA, which is the lead education agency or the school, the parent, and relevant members of the child's IEP team must review all relevant information in the child's file, including the child's IEP, any teacher observations, and any relevant information provided by the parent in order to determine if the conduct was caused by or substantially related to the child's disability. Or, don't miss this part, if the conduct was a direct result of the school's failure to implement the IEP. If the answer is yes, then this is a manifestation, and the school should act accordingly to address the behaviors as mentioned above. In addressing the misconduct, they can do such things as a functional behavioral assessment, a behavioral intervention plan, or modification to a current plan, and or any necessary steps to address the behavior. Unless the parent and the school agree to a change in placement as part of the modification for the behavioral intervention plan, placement stays as is while the school works to address the unfavorable behaviors. I've given you a lot of information, and we will summarize it all in just a minute. But before we do that, let us quickly touch on the MDR process under Section 504. The bottom line, the requirements under Section 504 are not so black and white. But the Department of Education and most courts interpret Section 504 as requiring an MDR when discipline will constitute a significant change in placement. So in IDEA, there is an explicit provision requiring an MDR and no change in placement while the MDR is being completed. Section 504, no explicit provision to guarantee that there won't be a change in placement. Yet, Whether your child is on a 504 plan or an IEP, I believe you would be well advised to request an MDR before the school implements a change in placement based on conduct. With that, now let's summarize. Children with disabilities, like all children, will sometimes behave inappropriately in a school setting. If this behavior causes the school to consider suspension or expulsion or removal from their current placement based on that behavior, then the school should do a manifestation determination review. If the behavior is a manifestation, then the school must maintain placement and address those behaviors. If not, then the school may proceed in accordance with procedures governing discipline and conduct as they would any child without a disability. My friends, we have come to the end of this video. Contact your local legal assistance office or the EFMP Central Cell if you have questions, as we are always looking forward to helping you build your advocacy toolkit. Also, stay tuned. In the next video, we will take a deeper dive into MDRs, looking at what constitutes the change in placement and much, much more.